Court here at West Virginia University College of Law. Welcome to the final round of the National Energy and Sustainability Moot Court competition that we are proudly hosting here in Morgantown, West Virginia this year. We are so happy to see all of your faces. We've had wonderful competitors over the past 3 days, and we are so grateful to have you here in Morgantown with us. I would like to give a special shout out to our dean who is here live in person, Miss Amelia Reinhardt. She's going to watch us have some incredible competitors tonight. And so thank you to the dean for all of your support of the Moot Court program. You are so very appreciated, and we're glad to have you. So I'm going to introduce our Energy Moot Court Competition Chair, Miss Maggie Lohman, and she's going to introduce our final panel of judges, and then we're going to get started with the final round. So congratulations to all, and here is Maggie.
Hi everyone, thank you so much for being here. We are so excited today to have a wonderful final panel. First, we have the Honorable Frank Folk, who is a U.S. District Judge for the Southern District of West Virginia. We have the Honorable Michael Alloy, who is a United States Magistrate Judge for the Northern District of West Virginia, and the Honorable Thomas Scar, Judge for the Intermediate Court of Appeals of West Virginia. And they get to hear from our final two teams, Team 22 and 24.
Admonished to draw near and give attention, for the court is now sitting. The case of Appalachian Clean Energy Solutions Incorporated versus Vandalia Public Service Commission will now be heard. God save this honorable court and the United States.
Please be seated. Well, counsel, we're ready to proceed, and you may commence.
Yes, Your Honor. May it please the court. My name is Stephen Hoffman, and I, along with my co-counsel, Olivia Donia, represent the appellant in this matter, Appalachian Clean Energy Solutions, or ACES. At this time, we reserve 2 minutes for rebuttal. There are 4 issues in this appeal, 2 of which I will be discussing today. First, I will discuss why ACES has standing to sue against Vandalia's capacity factor order. And second, I will discuss why the capacity factor order is preempted under the Supremacy Clause. My co-counsel will then discuss why Vandalia's right of first refusal is invalid under both the Supremacy and Dormant Commerce Clauses. Your Honors, today's case is about a clean energy company's attempt to break into a regional market and a state's attempt to remain adamantly stuck.
So what's so clean about natural gas as opposed to solar, or wind, or water?
Well, ACES is a global energy company, Your Honor, that is committed to achieving zero emissions by 2050.
What are they doing here? It's gas, isn't it? Isn't that what they want to do, a natural gas or generating plant that then generates over transmission lines, right?
Yes, Your Honor. They will be working in natural gas, which is carbon neutral, Your Honor, as opposed to coal. Now, this case is also about a state's attempt to remain adamantly stuck in coal production. And the district court has erred in finding that ACES lacks standing to sue when the capacity factor order at issue effectively sets an interstate wholesale rate, making it impossible for ACES to predict the future of a market in which it is already substantially invested. The district court also erred in finding that the capacity factor order is not preempted under the Supremacy Clause, when it is in fact both field and conflict preempted and is tied to the federally regulated wholesale market. Now, beginning with the issue of standing, a plaintiff or petitioner has standing to sue when they have suffered an actual or imminent injury in fact that is both concrete and particularized, that is fairly traceable to the defendant's conduct, and which a favorable court decision is likely to redress. And the injury in this case occurs in the interstate wholesale market.
Well, you're not subject to the capacity factor order, is that correct?
That is correct, Your Honor.
And you're not a ratepayer in Vandalia, right?
Correct.
And also Rogersville hasn't been built yet.
That is correct, Your Honor.
So tell us what your injury is.
The injury in this case comes in the form of market uncertainty. ACES, as you can see on pages 5 and 6 of the record, has committed to building the Rogersville Center as well as the Mountaineer Express. The Mountaineer.
So go back. I mean, nothing sounds more speculative than market uncertainty.
Your Honor, it is the fact that this capacity factor order introduces market uncertainty into the PJM market, which is a concrete and established fact.
And how does it do that?
Well, normally, Your Honor, a interstate wholesale rate is based upon the supply and demand of electricity in the region, so that a higher wholesale rate indicates a higher demand for electricity. However, as has been held in Hughes versus Talon Energy and PPL Energy Plus versus HANA, where a state regulation interferes with that wholesale rate by providing a subsidy to certain utilities, those utilities are getting a essentially higher value for the energy that they produce.
So how's that happening here?
In this case, Your Honor, the capacity factor order requires two utilities in Vandalia, Last Energy and MAPCO, to operate at a 75% capacity factor. And if they cannot achieve this, they must engage in recovery in the form of retail rates.
Well, it's not just that. You've got a finding of fact by the PSC that the 75% threshold is going to be met, right? How does that impact your entry argument?
Your Honor, this finding of fact by the PSC does not reflect reality when the utilities themselves have stated they cannot economically achieve excuse me, a 75% capacity factor percentage. In previous years, they've been unable to achieve that percentage, and the Vandalia Citizens Action Committee has also produced a finding that these utilities cannot run economically at a 75% capacity
Well,
factor.
we see fact finders all the time, whether it be juries or judges or administrative bodies who, in our opinion, might get it wrong, but we nevertheless owe them some deference. Do we not owe any deference here to the commissioner?
In the case of the mountain of findings to the contrary, the appellant would argue that this finding of fact by the PSC is clearly erroneous. However, even failing that, the fact that the capacity factor order itself, the Vandalia PSC reserves the right to increase or decrease the required capacity factor that these utilities must operate at. There are no findings of fact that the utilities can operate at an 85%, 95%, any other required capacity factor percentage. And from ACE's perspective, they can no longer tell whether the interstate rates are actually based upon supply and demand of electricity, or whether competitors are just raising their rates to compete with Last Energy and MAPCO, resulting in a higher interstate rate. That is the.
I think we understand your argument on that. So talk to us about redressability.
Yes, Your Honor. As the capacity factor order is the culprit, the one that introduces uncertainty into this market, this court can redress the issue by striking down the capacity factor order, thus eliminating this uncertainty from the market and allowing ACEs to capitalize upon their investments.
And so let me ask you what your basis is for us striking that.
Yes, Your Honor. Under the supremacy clause, the capacity factor order is both field and conflict preempted. Beginning with field preemption. When a federal regulation so fully occupies a certain field that it leaves no room for state regulations, those regulations are impliedly field preempted. In Section 824 of the FPA, FERC has been given exclusive jurisdiction over interstate wholesale rates. And the Supreme Court has repeatedly found in Hughes versus Talon Energy, Nana Tahela versus Thornburg, and Mississippi Power and Light versus Mississippi, that where a state regulation sets or has the effect of setting an interstate wholesale rate, it is intruding upon the exclusive jurisdiction of FERC and is therefore preempted.
So I presume you're saying that the capacity factor order has the effect of setting. Is that the case?
That's correct, Your Honor.
Are you saying that it sets the rate or has an effect on the rate?
The latter, Your Honor. It has an effect of setting the rate because though the price recovery in the CFO is based upon retail rates, for two primary reasons, the capacity factor order is tethered to the wholesale market and makes it distinguishable from other cases such as the ZEC line of cases, which can be distinguished from cases such as Hughes versus Talon Energy.
Well, my understanding, this is just going to be a transmission line through the state of Vandalia. So basically going to North Carolina, how is that gonna have any effects on what the rates are in Vandalia?
Well, to clarify, Your Honor, the capacity factor order solely applies to two utilities within Vandalia. They're not the ones building the transmission line. ACES, the appellant, is the one seeking to build a transmission line through Vandalia.
But what electricity is that gonna bring to Vandalia, and therefore, how does it help any rates in Vandalia? Does it?
Your Honor, the Rogersville Energy Center and the transmission line will be providing electricity wholesale to the PJM region and not specifically Vandalia, though it is noted in the record that there's a potential for intermediate substations along the line.
But it's meant basically to take energy to North Carolina and just go right through Vandalia.
Yes, Your Honor, that is correct.
Why should we feel good about that?
Well, Your Honor, first being that as part of the ACES as attempting to become carbon neutral to achieve an efficient and renewable source of energy, making this transmission line, allowing natural gas to be transferred, primarily in the goal of efficiency, allows.
I'm just trying to understand carbon neutral and natural gas, because that's what you're doing, right? So how does it get us to carbon neutral?
Your Honor, as part of the decarbonization effort of ACES, they are planning on shutting down various coal-fired plants in return for natural gas plants, various other more renewable and efficient energy sources, power plants for those.
You know, when you talk about this capacity factor order and it distorting price signals in the PJM market, the linkage probably has to be pretty tight there for the distortion you're speaking of. Draw that as narrowly as you can. What's the tightest level of that linkage? Because frankly, if we're looking at the supremacy clause, one of the bargains at the convention was that that wasn't going to be used, or if it was used, it was going to be used in the most narrowly tailored way, so.
Yes, Your Honor. Two factors that make the capacity factor order so comparable to Hughes versus Talon Energy, in which preemption was found, is the fact that the subsidy paid to Last Energy and MAPCO is the difference between the wholesale rate and cost of operation. So if the wholesale rate is 30 megawatt hours, cost of operation is 50 megawatt hours, the amount of subsidy paid is 20 megawatt hours, no exceptions. And this can be distinguished from other subsidies in which it is simply a flat rate or based upon factors outside of the wholesale market.
Well, when you're talking about future entries, let's say that the PSC, for whatever reason, it loses a commissioner or two, and this whole policy's changed. Do you have to worry? Do you have to show anything with respect to future standing? And we're not talking about this happening tomorrow, of course.
I'm sorry, could you please, just to clarify your question about?
Are you talking about a future or a present injury here?
In this case, the injury is present so far as ACES already sells into the PJM market, but is imminent in the sense that it is still planning on building the Rogersville Energy Center and the Mountaineer Express transmission line.
Is it your position that risk of harm alone is an adequate injury?
In this case, Your Honor, the risk created by the uncertainty in the market is sufficient to create adequate injury. Yes, Your Honor. The other factor that ties or tethers the capacity factor order to the interstate wholesale market is the fact that, pursuant to their FRR status, the two utilities under the capacity factor order are required to sell into the PJM market, guaranteeing that their rate recovery will be reflected upon interstate wholesale rates within the PJM market.
If they have a rate recovery, and I think that's at the center of this standing controversy that we're talking about. You know, again, we go back to the finding of fact. How does that all intermix to your client's benefit?
The finding of fact by the Vandalia PSC, the appellant argues, is clearly erroneous, as shown through the previous years that these same utilities have been unable to operate at 75% capacity factor, and also for the fact that Vandalia PSC can increase the required capacity factor percentage so that there is still uncertainty in the market. ACES can never tell whether or not Vandalia is simply changing the rules of the CFO and causing the interstate rate to change as a result, or if the interstate rate is actually accurately reflecting supply and demand within the PJM region.
So let me ask you on this period of time, so to speak, that the plants are up and running and demonstrating their capacity in Vandalia, pardon me. What kind of a track record do we have for those percentages? Is it back 3 years, 5 years, 7 years?
Your Honor, page 7 of the record shows the 2020 to 2021 capacity factor percentage for these utilities.
And do you know from the record what that is attributable to? In other words, is it just cyclical maintenance, or were there significant changes being made to the operations? Because, we're looking at a very narrow window of time. If there were substantial improvements made that might increase that percentage of uptime, then that changes everything, doesn't it?
Yes, Your Honor. The record states from the utilities themselves that they had run at a lower capacity factor percentage in order to bring down retail rates to their customers within the Vandalia region.
So does that mean then that they can consequently increase it if they need to get more in line with the finding of fact that the commissioner made?
Well, based on the contrary findings of fact by the Vandalia Citizens Action Commission.
You may finish.
Yes, Your Honor. Based on the finding by the Vandalia Citizens Action, I see my time has expired. May I briefly?
I'm going to let him continue. Go ahead.
Yes, Your Honor. Based on that contrary finding, the appellant argues that the that the utilities are unable to run efficiently at a 75% capacity factor percentage.
I understand, but that's not a creditable finding of fact, correct? It's by a citizens organization.
Yes, Your Honor, that is correct.
Understood.
For those reasons, we ask you to reverse the district court's decisions on standing and on the supremacy clause. Thank you.
Thank you very much. Counsel?
Good afternoon, Your Honors, and may it please the court. My name is Olivia Donia, and along with my co-counsel, Mr. Stephen Hoffman, I represent the appellant in today's case, Appalachian Clean Energy Solutions, Inc., or ACES. As you heard from my co-counsel, today's case concerns a clean energy company's attempt to break into a market that has passed protectionist laws to decrease competition in the state. And I'm going to discuss for you Vandalia's right of first refusal and whether it violates the supremacy clause of the Constitution or the dormant commerce clause of the Constitution. In both cases, the answer is yes. First and foremost, Vandalia's right of first refusal violates the supremacy clause because it's both field and conflict preempted by federal law in the area.
Are you claiming this is facially discriminatory?
For the dormant commerce clause, we are, Your Honor. To begin with, though, we are going to discuss the supremacy clause. And under Supreme Court precedent, where federal law has so comprehensively legislated in areas as to leave no room for states to supplement the law, the Supreme Court has held that state law is field preempted by Congress wholly occupying the field. This is one of those areas in which federal law has so completely occupied the field.
So are you saying any kind of effort to give a right of first refusal violates the supremacy clause? It's just not possible?
Your Honor, any kind of right of first refusal that has the effect of setting unjust rates in contravention of FERC order is preempted by the supremacy clause.
But there's nothing on its face that suggests it has that effect, does it? It's just a right of first refusal. One of the companies providing energy is from Ohio.
Yes, Your Honor. FERC, in its Order 1000, has made several findings of facts that rights of first refusal lead to unjust and unreasonable rates, as well as a stifling of innovation in the energy market.
So it sounds like you're arguing that there is no such thing as a valid right of first refusal.
In this instance, Your Honor, we are arguing that
In any instance?
There are instances where rights of first refusal have been valid, but they are considerably more limited and for shorter time periods than the one at issue in Vandalia.
What's wrong with 18 months? It's not at least indefinite like Texas.
Vandalia's 18-month right of first refusal essentially bars outside companies or non-incumbents from entering the market because it places an exceedingly high burden on these companies. In the 18 months where incumbent utilities have the opportunity to build this line, outside markets will struggle to find funding or investors or to adequately be able to plan an investment to enter the region because the 18 months will effectively stifle and prevent their attempts to enter the market. Because this law prevents non-incumbents from entering the market, it is preempted by federal
It
law.
only prevents them for 18 months.
Yes, Your Honor.
Okay.
So the Federal Power Act, which governs FERC, was passed by Congress in the mid-1930s, and the act gives FERC exclusive jurisdiction in two key areas, namely in the provision of interstate electricity or the transmission of interstate electricity, and in the wholesale interstate rate for electricity.
How much time's left on the 18 months?
We are about halfway through it, Your Honor. So I believe
9 months is excessive?
I believe we have 6 more months to go, Your Honor.
Less excessive.
So ACES has been barred from making any kind of move on its significant investment in the Vandalia region because of this right of first refusal.
How are you going to be harmed by another 6 months?
Well, Your Honor, it's possible that they may lose the line entirely because it could be that an incumbent like Last Energy or MAPCO capitalizes upon the right of first refusal towards the end of that 18 months.
Why should this court decide the issue instead of FERC deciding whether or not this violates the supremacy clause?
Your Honor, FERC has made several findings of fact in Order 1000 itself. Actually explicitly finds that rights of first refusal are leading to unjust and unreasonable rates. FERC's order applies in this area.
Well, did the FERC order say they are no longer valid? They could have said that, couldn't they?
The FERC order explicitly states that rights of first refusal must be removed because specifically they're stifling innovation in the market and leading to unjust and unreasonable rates for ratepayers within regional transmission organizations.
But there are rights of first refusal that FERC has allowed to be enforced.
Yes, Your Honor. As I've mentioned, these rights of first refusal, most notably the one at issue in LSP Transmission Holdings v. Zeben, was both shorter and more limited than the one in Vandalia. In Minnesota, the right of first refusal only applied to transmission lines that were over 100 kilovolts and was for a significantly shorter 90 days. That 3-month versus 18 months difference is significant in the burden it places on outside entrants into the market.
Are there any other ways that ACES might, say, circumvent or get around this right of first refusal?
In order to build ACES's line, or the Mountaineer Expressway, there are very few other ways to do this. ACES would have to invest a unduly burdensome amount of money in purchasing an existing incumbent company. That is to say, if the incumbent company chooses to sell to ACES at all, just to build this line in the state. Vandalia's right of first refusal has the effect of eliminating competition from the market and therefore leads to unjust and unreasonable rates. This directly conflicts with the federal goal of the Federal Power Act. As I've mentioned, Section 824E of the Federal Power Act gives FERC the authority to examine where rates or practices or rules may be creating unjust and unreasonable.
But it seems to me the policy reason behind the right of first refusal is that we have a history with the present provider. And we know whether it's a good or bad history, but we have a history with them. They're predictable. We know who they are. They aren't some outsider. We know what will happen. And so, I mean, what is so wrong with that as far as a public policy issue, that there should be some deference to those who have been in your community, have been providing that energy, has a commitment to that, as opposed to just putting some outsider on an equal ground?
Your Honor, Vandalia certainly does have an interest in maintaining reliability with companies in the community. However, the way they have chosen to maintain that reliability violates the Dormant Commerce Clause. These points about reliability of the company go to the Pike v. Bruce Church balancing test, which is used in Dormant Commerce Clause cases where a law has the effect of discriminating against interstate commerce. And under this test, the court must weigh the burdens of the law places on interstate commerce versus the putative benefits. In this case, the benefits by the law that are enacted by the law, such as the reliability and the knowledge incumbent providers may have, are not entirely significant because the
So
removal.
You're
Yes.
going to give me the other balance, right? as
I
to
will,
why-
Your Honor.
Okay, go ahead.
These aspects highlighted by the PSC, such as reliability, do not disappear in the absence of a right of first refusal. If the right of first refusal were removed, incumbents would still have the opportunity to bid in a competitive market. And it's very possible that things like their reliability or knowledge of the existing customer base gives them the edge in that competitive market. But the fact of the matter is, those things can still win incumbents' bids and serve this interest by Vandalia in a truly competitive
Let me
market.
ask you something along the lines of a statutory construction question. In Vandalia Code, Section 2412.2F, are you with me on that?
I am.
It talks about, for instance, a power district. There are a lot of small towns in Vandalia, as you know. What would stop your entity from penetrating the market in a very limited way and becoming a joint venture with some small power district in our state, and then you qualify as an incumbent electric transmission owner?
Your Honor, while it's possible ACES could do that, this creates something of a stepping stone that ACES must pass just in order to enter the market. The fact that Vandalia's right of first refusal law requires this local presence at all is violative of the Dormant Commerce Clause. In two notable cases, Granholm v. Held and Lewis v. BT Investment Managers, the Supreme Court held that the Dormant Commerce Clause analysis doesn't really turn on the empty formality of where a company may be headquartered, but rather found that state laws which or discriminate against a party based on a lack of local contacts with the economy may be violative of the Dormant Commerce Clause.
But the two other entities, MAPCO and Last Energy, aren't incorporated in Vandalia, are they?
That's correct, Your Honor. However, under this holding by the Supreme Court in Lewis v. BT Investment Managers, physical presence requirements in a state can still violate the Dormant Commerce Clause because they nevertheless further the issue of economic balkanization that
But
the
they're not
Dormant.
requiring a physical presence here, right? They're just requiring that you've been doing business here, and so we have some history with you, and that's the place of the right of first refusal. All of these companies may be out-of-staters, but they've been doing business here. They have the benefit of that statute.
Your Honor, under Supreme Court precedent, this kind of requirement that a state law places that a company may be discriminated against based on lack of contacts with the local economy still runs afoul of the Dormant Commerce Clause. And that's precisely the case here. The law at issue is very similar to the one the Supreme Court struck down in Lewis v. BT Investment Managers because it requires the state's so-called seal of approval based on their present contact and present business in the state in order to merely compete in the market. These kind of laws go against the ideas of the Dormant Commerce Clause because they decrease competition and, to the point of the Supremacy Clause, increase unjust and unreasonable rates in direct contravention of the federal goals of the Federal Power Act and FERC's Order 1000. Furthermore, even if this court should find that Vandalia's right of first refusal is not facially discriminatory, it still is.
Let me try to isolate the inquiry again, because I want to make sure I understand your argument, at least under the Commerce Clause component of it. We understand the law as to that particular argument to be that courts will strike down a state law if that law expressly mandates differential treatment of in-state and out-of-state competing economic interests. Now, that's not quite what we're dealing with here, is it? And if it is, please illuminate me.
It is what we're dealing with here in something of a more roundabout way. As you know, MAPCO and Last Energy are headquartered outside of Vandalia, while ACES is headquartered inside of it. But as I've mentioned, the court precedents are do not read the Dormant Commerce Clause exactly so narrowly. The Supreme Court has held that lack of contacts with the local economy can be discriminatory under the Dormant Commerce Clause, and several circuit courts have held so as well. The Fifth Circuit case Next Era v. Lake considers a right of first refusal almost exactly the same as the one here, aside from the time component. In that case, the Fifth Circuit held that such a law violates the Dormant Commerce Clause because it draws this line between competitors in the market based on where they are physically doing business.
I don't mean to interrupt you unduly, but before your time closes, your opponent is very likely going to get to stand up here momentarily and demonstrate a non-protectionist purpose and the unavailability of less discriminatory means for achieving that purpose. As your final closing statement, I'd like you to say why that's not going to carry the day.
Your Honor, the legislative history of the Native Transmission Protection Act, which is protectionist in its name itself, shows that this law was enacted to decrease competition. On page 9 of the record, you'll see that the legislator who introduced it in order to restore the status quo that was disrupted by Order 1000. May I briefly conclude, Your Honor? I see my time has expired.
Absolutely, please finish.
Your Honor, the legislative history of this law is blatantly protectionist. Supporters of the law explicitly urged the legislature in Vandalia to enact it in order to keep competitors out of the market. And for that reason, the burdens of this law substantially outweigh its benefits, and we ask you to reverse the lower court's decision. Thank you.
Thank you, counsel.
May it please the court. My name is Megan Bechtel, and my co-counsel, Margaret McAllister, and I represent the Vandalia Public Service Commission in the case of Appalachian Clean Energy Solutions v. the Vandalia Public Service Commission. This court should affirm the district court's motions to dismiss. This case is about ensuring that Vandalia can provide adequate, economical, and reliable utility services to its constituents. I will argue that ACES lacks standing to challenge the capacity factor order, and the capacity factor order does not violate the Supremacy Clause, nor is it preempted by the Federal Power Act. My co-counsel will argue the two issues related to the statutory right of first refusal. ACES lacks standing because their alleged injury is merely speculative, failing the first prong of the standing test that they allege a concrete and imminent injury in fact. First, ACES is not the object of this regulation. Nothing in the capacity factor order mandates ACES to do anything. They're not a retail utility in Vandalia. And importantly, nothing in the order prevents them from building their Rogersville energy facility or competing in PJM wholesale markets. The cases of LSP Transmission Holdings and MISO Transmission customers are illustrative here. They said an energy service provider satisfies standing when they can show that they are ready and willing to perform, and they're completely blocked from doing so. Here, ACES is not blocked at all from competing in PJM wholesale markets with their Rogersville energy facility.
But isn't it essential to the Rogersville facility to be able to transmit energy through Vandalia? And so if that's the case, they are harmed by this?
Your Honor, nothing in the capacity factor order would prevent them from being able to transmit energy into PJM wholesale markets. They allege that
Then how would they do it, though?
Well, the capacity factor order just mandates that Vandalia's coal retail utilities operate their coal plants at a certain rate, but they can still access ACES will still be able to access transmission to sell their power into PJM, whether that transmission goes through Vandalia or not.
Well, how do you get to North Carolina other than through Vandalia?
Well, Your Honor, the standing issue is related to the capacity factor order, which just relates to the coal mandates rather than the transmission
the right of first refusal.
That's what follows, though, right?
Yes, Your Honor. But their Rogersville Energy facility, they may not be able to compete in PJM wholesale markets, which makes this injury even more speculative. They say that their injury is present, yet nothing in the facts suggests that the Vandalia coal utilities have actually changed the way they're operating their coal plants or the price they're bidding their coal plants into PJM as a result of this capacity factor order. And this capacity factor order has been in place since May 15th.
Do we have to uphold or pass favorably upon Chairman Williamson's 75% benchmark or finding in order to sustain your position?
No, Your Honor, you don't have to, but I suggest you accord considerable weight because the Public Service Commission in Vandalia is the body charged with regulating Vandalia's retail rates and ensuring that Vandalia has enough and their retail utilities have enough energy to reliably
But
meet the needs.
doesn't it also seem, in all fairness, that they've also apparently charged themselves with protecting coal at all costs?
Your Honor, the Vandalia Public Service Commission has decided that operating the coal plants at this level would best serve the public interest. Vandalia does have a significant amount of coal, so likely providing coal energy to
Sometimes discrimination serves the public interest when it comes to matters of this type, at least. So we can't simply say that the public interest is served and then leave the matter. I have to tell you, that 75% benchmark seems like a thumb on the scale. It seems like it was pulled out of thin air to arrive at a result that would perhaps make the factoring order a little stronger. And there is a considerable variance between the production numbers you see in the record versus that 75% finding. So how in the world do we sustain that?
Yes, Your Honor. The utilities did present alleged facts that they would not otherwise produce this 75% capacity factor rate. But like I said, this capacity factor order has been in effect since May 15th, and ACES failed to allege any facts to suggest that this failsafe has even gone into effect or done anything to impact the prices that Vandalia coal utilities are bidding into the market at, so this injury remains purely speculative. And even if ACES had standing, their challenge to the capacity factor order would still fail. The capacity factor order is neither field nor conflict preempted.
I think Judge Scar may have had a question for you.
Yes, Your Honor.
What evidence, if any, do you have that would support, any evidence in the record that would support the chairman's view?
Your Honor, the chairman's view is based on a finding of fact that was conducted by the Public Service Commission, who is charged with making these kinds of findings and determinations.
We know what they're charged with, but I'm interested in the same question, what in the record supports it.
Nothing in the record, other than that in the record, supports the fact that they would meet the 75% capacity factor order, but the burden is on ACES to provide facts that allege standing sufficiently, and they failed to do that either.
Well, both the chairman and the PSC basically take the position that it would automatically be 75% even if they didn't have the capacity factor order. So they're taking the position, or you're taking the position, that they entered that order, which was totally unnecessary.
No, Your Honor. The chairman said that it would be economical to provide for the utilities to provide energy at the 75% capacity factor order. The utilities may not have chosen to do so without this order, but because it's economical to do so, they very well may not have to, distort any rates, which ACES alleges could be an injury to them. But they have provided no facts to suggest that these coal utilities are actually distorting their rates.
What motivation would the two companies have not to produce at a greater amount if it was, in fact, economical to do so?
The utilities said that for their reasons of public interest, they decided that selling other energy would be cheaper, but the Vandalia Public Service Commission, maybe not for the coal energy being cheaper, has made other determinations that operating these coal power plants at the 75% capacity factor best serves their ideas of public interest. And states have broad authority to make these determinations of public interest when regulating energy matters within their state.
If that's the case, would that not then directly conflict with the authority of FERC to control the pricing?
No, Your Honor. The capacity factor order is not field preempted by the Federal Power Act. It does not indirectly set rates, which would be impermissible under FERC's jurisdiction over wholesale markets, nor does it compel participation in wholesale markets. You know, the federal government has the exclusive authority to regulate wholesale markets, but states have the authority to set retail rates and make determinations of the types of energy capacity and the need for amounts of energy capacity and other determinations of public interest when serving the energy consumers in their state. And the capacity factor order relies on recovery through retail rates. This energy will still be bought and sold at the rate determined by the wholesale market, but Vandalia has decided that it would be prudent for these utilities to recover the cost of producing coal, even if it's at a loss based on the price set by the wholesale market. And the regulators have broad discretion in setting retail rates. The Supreme Court in Hope Natural Gas Co. held that regulators have discretion in setting retail rates and deciding what costs their regulated entities can recover. And this was affirmed in the context of a state regulator in Duquesne Natural Gas and Light Co. v. Baruch. So the Vandalia Public Service Commission is exercising their traditional authority to set retail rates and in determining that they can recover the costs of complying with the capacity factor order.
But doesn't just building in that mechanism for cost recovery suggest the PSC knows this isn't going to be workable?
No, Your Honor. States can make decisions that accord additional.
Well, but I think it's a factual question. There's this 75%, and have they ever reached 75%? Is there anything in the record to suggest they've ever gotten close?
They have gotten close. One of their coal plants got to 64%, but there's
It just seems like it's made up, quite honestly, to prevent what ACES is trying to do.
Oh, Your Honor, the Vandalia Public Service Commission has decided that this best serves the reliability interests and other public interest
But
considerations.
they can't just make it up. Doesn't have to be some factual basis, or they just make it up and say it serves the interest.
Your Honor, states can make these determinations of public interest, and we don't necessarily have to reach into their minds as long as their rules do not somehow intrude on FERC's sole jurisdiction over wholesale markets, nor their goals for competitive wholesale markets. And
Let's say that the 75% wasn't there, that Chairman Williamson didn't make that finding. Where would that leave this particular scheme? Cost recovery would be pretty gigantic then. It would still have a considerable effect on the market in that situation, wouldn't it?
Well, Your Honor, the state would still be able to allow this cost recovery as long as it is not tethered to participation in wholesale markets. And we know that states can give additional payments to generators in addition to what they receive on the wholesale market, and these rates can have incidental impacts on the wholesale market without it violating the supremacy clause. In Hughes, the court said, and I quote—
But at what point when do you reach the tipping point, so to speak?
Your Honor, here we don't need to make any kind of determination of the tipping point. If Vandalia's retail customers find that an order like this maybe sets their rates too high, they have avenues to address with the Public Service Commission to possibly change that order. But in terms of the Supremacy Clause analysis, as long as this regulatory scheme isn't somehow indirectly regulating the price of wholesale markets, then we have no Supremacy Clause issue here. And this rule is not tethered to wholesale market participation. In Zibelman, plaintiffs tried to make an argument that this is a zero-emission credit cases, that just because all the nuclear generators that receive zero-emission credits sold their power into NYSO wholesale auctions, the receipt of these zero-emission credits was tethered to wholesale market participation. But that argument didn't hold any weight with the court. The court held that the zero-emission credit cases were not tethered to wholesale market participation. Similarly here, like in the ZET cases, these generators may receive an additional payment in the form of cost recovery, but this is not tethered to participation in wholesale market. In wholesale markets, that's rather a practical effect of their fixed resource requirement status with PJM.
Have you been heard on your second argument? Want to make sure you have an opportunity to.
Your Honor, yes. I just want to conclude that the capacity factor order does not compel wholesale market participation either, but rather mandates that the utilities use a certain amount of, or a certain type of energy for these sales they would already be making. As a result of this fixed resource requirement status, they exclusively sell energy into PJM. And it's consistent, may I briefly conclude this point? It is consistent with other state determinations of public interest. For example, in the zero emission credit cases where the state has said, you know, we would like you to preference nuclear energy. The state is rather saying, we think it's best in line with the public interest for these sales you would already be making to have 75% of your coal generation capacity in operation. So for those reasons, Your Honors, ACES lacks standing to challenge the capacity factor order, and the capacity factor order does not violate the supremacy clause. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Margaret McAllister, representing Vandalia Public Service Commission. May it please the Court. The Native Transmission Protection Act is a lawful exercise of Vandalia's historically recognized police powers. NTPA preserves Vandalia's long-standing local utility practices and ensures safe and reliable electricity supply for its residents. The absence of federal regulations in the arena of state ROFR laws and the absence of overt discrimination defeat any constitutional challenge to NTPA. NTPA is not preempted by Order 1000. With any preemption challenge, the basic assumption is that the historic police powers of the state are not to be preempted unless that was the clear and manifest purpose of Congress. Appellant concedes that that there's no express preemption in Order Number 1000 because Order Number 1000 specifically names removal of federal ROFR laws.
So tell me the factors in Order 1000 and how it is that Vandalia's, based upon that analysis, doesn't violate the supremacy clause, their right of first refusal.
Yes, Your Honor. The Order Number 1000 abrogated the federal right of first refusal, not any state right of first refusal. And in fact, FERC limited the reach when they stated, nothing in this requirement affects state regulations regarding the construction of transmission facilities. FERC explicitly said that they did not intend to intrude on historically recognized police powers. Moreover, FERC has tacitly, impliedly approved for federal or state ROFR laws in the LSP transmission case. We know
What's the purpose of Order 1000?
The purpose is generally to increase competition at an interstate level, but also maintain the state and federal balance, which in the electricity regulation is a delicate one.
It's hard for me to imagine, though, why a right of first refusal drawn in this fashion wouldn't contravene the purposes of Order 1000. So maybe you can focus some attention there.
Yes, Your Honor. So the purpose of Order Number 1000 was to remove the federal right of first refusal. And we know that this is a quote from Bonito Boats v. Thundercraft Boats, the case for preemption is particularly weak where Congress has indicated an awareness of state law in a field of federal interest and stands by both concepts. We know in LSP Transmissions Holdings v. Sieben that the court upheld FERC's own decision to allow a state ROFR in a MISO tariff. FERC made a determination that endorsed a state ability to maintain a ROFR law and comply both with Order 1000 and state regulations. We know that MISO incorporated Minnesota's state ROFR law, and the approval of that reflected FERC's intent to honor state ROFR laws. So the supremacy clause was not violated there, and it is not violated here.
The laws you're talking about, they've all been different. You're not suggesting that FERC has thrown up its hands and will now allow any right of first refusal statute?
Not at all, Your Honor. There definitely are major differences across ROFRs in the United States, but we do know that several states have enacted state ROFR laws that remain unchallenged. Those states include Iowa, Indiana, Michigan, Minnesota, Montana, North Dakota, and South Dakota. And
What are their waiting periods?
So the waiting periods range. In North Dakota and South Dakota, the waiting periods are indefinite. In the upcoming Kansas ROFR, which is going to be implemented, the waiting period's 18 months. the waiting period in Minnesota was facially 90 days, but that 90-day limit was for an letter of intent to be submitted.
And
then
you're saying they haven't been challenged?
I'm saying that the only challenges to state ROFR laws are in two cases, the LSP Transmissions holding case and the Next Era case. LSP Transmissions is materially the same as this case, materially identical. Next Era is inapplicable here because
You say it's materially identical. Tell us from a devil's advocate standpoint how it differs.
Yes, Your Honor. ACES would contend that it differs because it wasn't an 18-month waiting period, but while the 90-day period was facially what was required, that was for a letter of intent to be submitted. The 18-month period there was actually a longer 18-month period, which was allowable for them to exercise their right of first refusal by making a bid. So it was 90 days in the context of what was litigated, but the actual deadline was much longer with 18 months, which is exactly what we have here. The Next Era case is also inapplicable, and that's a case that appellant heavily relies on. In that case, in Texas, and as we all know, Texas has a very unique grid system where the Public Utility Commission of Texas regulates electric utilities, but the independent system operator there, ERCOT, operates wholly within the state of Texas. So that case was materially different for two reasons. First, as was identified earlier, it was a complete ban on new entrants because it was a lifetime, an indefinite ROFR. So at no point could a new entrant actually enter the market because the ROFR could be executed at any time.
Aren't the nature of ROFR laws really enacted by states protectionist and doesn't at its core really violate the supremacy clause? Because that's what they're about.
Your Honor, they don't violate the Supremacy Clause, nor do they violate the Dormant Commerce Clause. The Native Transmission Protection Act, while it invokes the dictionary term protection, it is not protectionist in the sense of a Dormant Commerce Clause analysis.
But it favors locals, right?
It favors incumbents. Incumbents can be incorporated both in and out of state, and the relevant law is persuasive that this court should also adopt a place of incorporation test. That's what was adopted in CBID, and that's what was adopted in colon health centers in the Fourth Circuit.
But that favoritism is what eliminates competition, which is healthy for the market, as argued by ACES. How does this not do that?
Your Honor, competition is surely an interest at the interstate level, but for the local end users, which under Vandalia Code 2411A2, Vandalia Public Service Commission is charged with regulating utilities to provide adequate, economical, and reliable utility services. This also aligns with FERC's mission. FERC's mission statement is to provide reliable, efficient, and sustainable energy for consumers. And that's the interest we're talking about with state ROFR laws.
In this highly competitive, highly regulated area, 18 months might as well be 10 years.
Your Honor, when we consider the actual timelines of projects like these, transmission line building often takes a decade or more to complete.
But they can't get started though, right, until the 18 months ends?
Your Honor, no, but there is often, in the construction of these plants, there is a long period that is dedicated to planning and permitting that ACES would have to go through otherwise. Just because they can't break ground on day one doesn't mean that they're discriminated against.
But here, they don't know whether they're going to even have the opportunity to proceed. It'd be one thing if they had to wait. Once they knew that they were going to be able to proceed, they could get the financing. But here, the question is, they do not know for at least 18 months whether or not they're going to have any right to construct the transmission line.
That's right, Your Honor, but that is permissible under both the Supremacy Clause and the Dormant Commerce Clause. And we know from Exxon Corp v. Governor of Maryland that, and I quote, where a state regulation must go beyond merely impacting a particular economic actor's profits and actually block the national market itself. That's the concern with ROFR laws, whether they actually block the national market. And that's what was wrong with the Next Era case. The Next Era case was correctly decided because the ROFR law actually blocked the national market because it was both indefinite and because of the unique grid system in Texas. This case is much more analogous to the LSP Transmissions Holdings v. Sebin case that we've discussed earlier, where there's an incidental waiting period, and after that, ACES can go ahead and construct its facility. As Your Honors also identified in questioning opposing counsel, there are also other ways for ACES to go about becoming an incumbent so that they can build a transmission line. For example, they could purchase any sort of transmission utility in Vandalia.
But don't you see the obvious problem we have with that? That's almost you, once again, encouraging, like the legislature, more incumbents, more to come into the state and, do the state a favor, so to speak, economically. That argument just doesn't really carry much weight in my estimation.
Your Honor, even if there are a greater number of incumbents, in fact, in the Sieben case, there were 16 incumbents, 11 of which were incorporated within the state, 5 of which were incorporated outside of the state. And FERC itself approved that determination. They approved that ROFR law.
Licensing fees are fine, and similar things like that. We have pay-to-play in states all the time. But to come in and make a gigantic investment like this just to be able to engage in commercial activities, that really strains us, especially when we're trying to keep rates down for the consumers.
Your Honor, ACES has not yet made any investment, except for in proposing.
Would you, with that kind of a waiting period?
Your Honor, yes, I would, considering the length of time that these projects often take. 18 months is a small percentage of the amount of time it actually takes to build. And they already acknowledged that dedicating a portion of their time should be for planning, siting, permitting, and waiting for ROFR laws to expire. We also know that the incumbents in this case, MAPCO and Lash Energy, have given no indication that they intend to execute their right of first refusal. So in all likelihood, ACES is going to be able to break ground in 6 months because we are already a year into the ROFR law, and then they will become an incumbent and they'll never have to worry.
Why should those two entities have 18 months to make that decision? And what incentive do they have to simply do anything other than sit on the fence and let that whole period expire before they say, yeah, we're not going to take it? And then by that point, ACES is probably not interested anymore. It's not economically feasible.
Your Honor, 18 months is the appropriate time frame because that is what FERC has tacitly approved. LSP transmissions is the only case in which FERC has actually spoken on a ROFR law and approved a ROFR law, and in that case, there was a 90-day period for a letter of intent to be filed and an 18-month period for a bid to be processed.
But that's the big difference, though. This would then press the hand of the incumbents to say, we have a notice of intent within 90 days that we're going to do it. That's a big difference, isn't it?
Your Honor, it is a difference, but I would contend, in the scope of what is actually impermissible, we know what's impermissible is a complete ban on the market. And we know that 18 months or 90 days, those are both incidental hurdles compared to the unlimited right of first refusal that was struck down in Texas.
But at some point, 18 months, 24 months, even 9 months perhaps, effectively becomes an indefinite requirement, doesn't it? And we're talking about a very competitive industry where you have to be nimble. You're not just dealing with national markets, you're dealing with international markets. So it just seems to really press the limits.
Yes, Your Honor, if we were to draw a line, which the court does not have to do today, an appropriate line would be at the length of the project time, which is about, on average, 10 years. That would be an appropriate limiting principle where it's a complete ban on new entrants because the new entrants would have to wait for the lifetime of a project in order to even begin the project.
But Judge Scar made an important point. That's really a myopic way to view things, how long it's going to take to construct it.
Your Honor, certainly the timeframes and the different, whether it's permissible based on 18 months or 90 days or impermissible based on an indefinite period of time, you're correct that it's silly to get bogged down in how long we wait for these ROFRs and what becomes what effectuates a complete ban. But we do know that FERC has approved an 18-month ROFR, at least impliedly. And we know that there are 18-month ROFRs in existence around the country that have been unchallenged. And we know for those reasons that it is a straight...
When you say impliedly, they didn't reach the question, did they?
No, they did reach the question. FERC approved... In the MISO framework, in the Minnesota case, FERC approved the ROFR law in Minnesota. And
Then why do you refer to it as impliedly?
just because of the 90-day, 18-month distinction, where in this case there was...
So it is different.
It is slightly different, but when we consider the only two cases on which FERC has spoken, and the extremes of those cases, the complete ban of the indefinite ROFR that operated in a unique grid system versus the 90-day letter of intent, 18-month bid, ROFR in Minnesota, which FERC approved. This ROFR is much closer to that case, and any limiting principle would be well beyond the 18-month window. We know that for a dormant commerce clause analysis, we must assess whether there is facial, purposeful, or effectual discrimination. But as a threshold question, we must ask whether the entities are indeed similarly situated for the purposes of a dormant commerce clause analysis. In General Motors v. Tracy, the court addressed a similar question about whether certain entities qualified as natural gas companies for the purposes of a tax exemption from state and local sales tax.
Well, on this dormant clause issue, both the Fifth Circuit and the Eighth Circuit has spoken on it. Why is it that that you think the Eighth Circuit decision is more persuasive?
Because, Your Honor, of the complete ban that operated in Texas. A dormant commerce, a state regulation must go beyond merely impacting a particular actor and must actually create a ban on the national market. We know that in, for example, Florida Transportation Services v. Miami-Dade County, where the port director was rubber stamping stevedore permits and only allowing incumbents, that was effectually creating a complete ban to new entry. The same was true in the NextEra case, where because of Texas's unique grid system and because of the indefinite length of the ROFR, there was a complete ban. Here, the law applies even-handedly to incumbents, whether they incorporated in or out of state, and it's not a complete ban on the market, but just an incidental period.
Here's the problem. I mean, the whole purpose behind a dormant clause is to protect discrimination. And isn't the nature of a ROFR discriminatory, just at its core?
No, Your Honor, the ROFR is geared with efficiency in mind. It's to make sure that Vandalia, this ROFR particularly.
It's meant to treat someone more favorably than someone else, right?
Your lawmakers have put in effect, title of the statute means something, the Native Transmission Protection Act, native protection. Don't you just have to surrender on discriminatory purpose?
No, Your Honor, because under DeMoore v. Kim in Justice O'Connor's opinion, she said, a title has no power to determine what the text of a statute takes away. They could have titled this anything, and even if we look
But the choice of the title says everything, doesn't it? It may not factor into the construction of the statute, but for heaven's sakes, if we're looking for discriminatory purpose, we don't have to look very far, do we?
And isn't it fair? The title pretty much represents the purpose of the act.
Well, if you go beyond the title, wasn't there evidence from those incumbents that they were supportive of that statute because it would give them some protection?
Your Honor, we don't look to what the incumbents believed about the law, we look to what the legislature said. And the legislature said that they wanted to encourage well-planned development and serve the market. We also know that under the final prong of the Dormant Commerce Clause challenge, under the Pike balancing test, there are legitimate local benefits here that outweigh any incidental burden. The benefit is reliability, and the Pike test has only been invoked in cases where it is apparent that there is no evidence of a legitimate local interest, as in Yerger v. Massachusetts Turnpike Authority, where the Massachusetts Turnpike Authority mandated that trucks put specific branded mud flaps on their may I briefly conclude on this point? They mandated that the trucks put specific branded mud flaps, but presented no evidence of a state or local interest, and that was clearly outweighed in the balancing test. Here you must consider the aggregate effects of reliability, efficiency, and sustainability. For those reasons, we ask that Your Honors affirm the ruling of the district court below.
Thank you. Your rebuttal?
Yes, Your Honor. May it please the court. Appellant has just one issue to bring up on rebuttal, Your Honors. The Public Service Commission stands before you today and asks this court to grant the State Commission the power to arbitrarily interfere with interstate electricity transmission apropos of nothing. When asked what evidence the chairman had to set a 75% capacity order, opposing counsel could answer twice, only that the chairman had decided it would be prudent to do so. With no evidence to support it, the state passed this kind of protectionist law. And there's a reason the Federal Power Act grants federal authority over transmission of interstate electricity commerce. And there is a reason the Dormant Commerce Clause prevents this kind of facial discrimination as seen in the right of first refusal. and that is to prevent precisely this kind of arbitrary state interference in the interstate commerce of electricity power. These laws serve only to protect Vandalia's interests and were not enacted with any kind of economical reason in mind. They only serve to further balkanize the states in their production of electricity and to harm the interstate market. And for that reason, the appellant respectfully asks this court to reverse the lower court's decision. Thank you.
Please stand while the judges exit the courtroom for deliberation. You can be seated. That's the winner.
Please be seated. Well, I want to first, and I'm sure my colleagues will do likewise, commend all four of you. Really did a splendid job with issues that were extraordinarily complex. I have colleagues in New York and California and elsewhere who don't often see issues this complex, much less yours truly. But one of the main reasons that I still am happy to drive 2.5 hours on a Saturday to come to these competitions is that it is very intellectually stimulating, and one of the reasons is that you all are so well prepared and give such excellent presentations. I will tell you that you have today eclipsed many of the practicing lawyers that appear before me, and that's not a surprise because you have devoted so much effort to it. I just would commend all of you again, and I would say you had the misfortune of being first out of the gates, and we had a lot of questions. I'm not sure that you even got to 10% of your argument, but you still pivoted very, very well despite the difficulty of the questions, and you responded to the questions even when the responses were very difficult, and nevertheless retained your poise in the process. So very well done. And remind me of the pronunciation of your game. Is Miss Adonia?
Donia, yes.
Adonia. You as well obviously had a terrific command of the issues that you were arguing, and you were also very strong in responses to questions. And you might have imagined that sometimes we ask questions that we know are a little misplaced in order to see how you correct us, because correcting a judge is a very difficult thing when they are making the adjudication, and you handled that very skillfully as well. And it's very easy to jump on a wrong answer and try to take advantage, but you're respectful. And again, obviously commend you on your command of the material. And Ms. Bechtel, you approached things very courageously. I think you may have had the more difficult of the issues on your team, but I think my colleagues may disagree with that. You nevertheless retained your poise as well and had a command not just of the law, but also of the record. And Mr. Bechtel is to be commended on that, Mr. Hoffman's to be commended on that as well. But again, the questioning was fierce for both you and your colleague. It was almost as if there was a little bit of blood in the water with that 75% matter. But you did excellent, really, really did. And Ms. McAllister, just a fabulous job. There's no other word for it. Really tried to make you bend a bit in several different areas, and you never did. But it's easy not to bend, but it's difficult to not bend and yet, again, retain your poise and demonstrate a command of the record that fortifies the points that you're making. And you really did a terrific job. All of you are excellent oral advocates and to be commended again. I'll call on my colleagues now.
Go ahead, Jessica.
Well, I agree with the comments of Judge Vogt. You all did an outstanding job. The level of work, preparation, and knowledge was, by all of you, was apparent. We had a hard time, not a hard time, but had to separate our own views of how this should turn out and the legal issues, because some of you had stronger legal positions to argue than others, just the lay of the land. And I think in earlier rounds, you may have had to argue on the other side, which is a true challenge and a true education and advocacy. I thought you all did an excellent job. A few of you felt or appeared to feel more comfortable in the presentation. And I think for those of you that did not or did not appear to be as comfortable, that will just take time. It will happen. And the one thing I think is whether you're an appellate court or in a trial court is you have to be yourself rather than trying to be what you think a lawyer is supposed to look like, act like, and behave. So I thought you all did a wonderful job. As time goes on, you'll even get better, which should scare your opponents down the road. But thank you.
Yes, congratulations on getting to the finals. I mean, it says something really special about all of you. Welcome to West Virginia. It's great to have you here. It's one of the things to follow up on what Judge Scar said is that it really is important to be yourself in your presentation. Who else can you be? And I've told people all along, I'll hear sometimes the best arguments are those who simply answer my question and do it in a way that answers that question, in a way that's fair. And if there's a weakness, there is. That's okay. And so there's this notion of flamboyance or presence and all that. And I think most of our courts are just working so hard to try to understand the case, the law, and what is the right situation under those circumstances. So if you always focus on that, you'll do your job, and that's what it is. That's all you can do. If you think about it in terms of winning and losing, that'll warp your whole presentation. It's a matter of, are we representing the law, the facts in a way that can support the court? Whereas Judge Volk is the master of the intentionally misplaced question, just to see if he can catch you. I'm the master of the unintentional misplaced question. So if you thought it was strategic, then don't think otherwise. But yeah. So, but you guys, I mean, seriously, you've heard it before, but people go whole careers that don't get to where you are right now. I mean it. And so you really should feel good about where you are, what you've done, and how well you've represented your schools. So it's great to have you all here. Good luck.
Before we remain at the bench but cede the authority to speak further to someone else, I wanted to tell you that in the early years, early decades, Supreme Court practice, that at times the advocates will go on for hours and hours, often in the morning and the afternoon. And it's unimaginable to me how they could do that. But it makes it so much more difficult for someone like you in the position you all have been put in to compress things and to keep your heads about you whenever these questions are coming, and to keep things in order. And just, again, very, very impressive. So we'll close it with that, but I think they all do deserve a round of applause.
I'd like to introduce Timothy Miller to announce the winner.
Oh, there it is.
May it please the court.
All right.
My name's Tim Miller. I'm with the firm Babs, Cowan, Clements, and Zomner with offices in Pittsburgh, State College, PA, Washington, D.C., and Charleston, West Virginia. I'm co-chair of the energy litigation practice. More importantly, I'm a proud graduate of the WVU College of Law. And for those reasons, I have a keen interest in this program and supporting it. So my firm and I have been graciously granted the honor of announcing the winners. We're also pleased to announce we will be awarding a $1,000 cash prize to the winning team and a $500 prize to the second place team. With that said, I am proud to announce that the winner of this competition is team number 22 from Georgetown University. And if I may add one final comment, I think also a round of applause is also due to Professor Van Nostrand, Professor Seifert, and all those, including those here who have organized this competition and put on such a top quality program.
Yes.